So now I'm going to take us through the LRA priorities, the Labour Relations Act. So this is the act governing unionized workers in the province of Ontario. And these are the priorities that we've honed over the last year and a half through meetings with many of the organizations who are in this room today, as well as labour unions across the province. We also had a series of 16 meetings of rank and file leaders in different locations right across Ontario. And we really appreciated the time that everyone took to talk these things through, because it's not easy to reach a consensus. So on the LRA side, there are some things that we'd like to see. Particularly, we'd like to see to make it possible to meaningfully exercise the right of association that all of us have guaranteed under the Charter of Rights and Freedoms. So if it's a charter right, we think that we should make it real. Ontario has the second lowest rate of unionization in Canada at around 27%. The lowest is down Alberta, and that's after 40 years of a Conservative government. So as the unionization rate drops, so go our working standards, which make it an issue for everyone. What unions win for their members, they often push to have written into law. So for example, most of our health and safety standards today are thanks to that work. Anti-harassment laws, same-sex benefits, parental leave, and there are a lot of other examples. And while legally we actually have the right to join a union, it's actually very difficult. So there are many barriers to the process, and they make it slanted towards the employer and against workers, as Shalom said earlier. And like Patty said, we don't think that unions are a solution to all problems. We certainly don't. But the laws need to make it easier for workers to exercise some power by joining together to make changes at work, so they can negotiate their own working conditions as a group. So we want to see, first and foremost, an end to all exclusions and exemptions under the LRA. No group of workers should be excluded just because of their job or their immigration status. This is ridiculous. We'd also like to see card check certification, so that you're only having to choose a union once. You're not having to choose it over and over again. We'd like to see the early disclosure of workplace information so that workers can find their co-workers to talk to them about joining a union, because right now it's very difficult. For anyone who has participated in volunteering for an election campaign, you know you have the voters list. And so no politician would dream of running their own election campaign without that voters list. But for some reason, as workers, we need to run unionizing campaigns without the list of who we're supposed to be reaching. We also want to see neutral online or telephone voting. And so this is so that we can avoid the harassment and intimidation that happens during the voting process, which is often a barrier. And we'll see this in a minute. Few technical things. We'd like to see remedial certification and expedited and extended power to reinstate workers before the first agreement. So that's having some more empowering the labor board to actually work on behalf of working people, which today they don't actually have that power. I think I'll get this right. Oh yeah, here we go. Okay, the next item is protection against in the case of contract flipping. So if you're on the Workers' Action Center Facebook page or on the website, there's a great video from a brother in the room, Abdul, who speaks about his experience working in the parking service sector. So that is a subcontracted sector, and it's a loophole that exists in the law today, where those working in subcontracted sectors like building services, parking, security, and others are at risk of losing their job and their union when the contract is flipped. So it's a very strange loophole that doesn't exist for other sectors. So we want this loophole to be closed. We also want to see broader-based bargaining, which would allow for different types of bargaining models to create stronger standards and protections across sectors. So regardless of whether it's a small workplace, franchise, independent work, etc. So it's a model that could apply for folks that have, because of the circumstance of their work, it's actually very difficult to organize a union. We also want to see the option of first contract arbitration. So that's for first collective agreements, because employers have two critical times when they can really break the union. So at the onset, when their workers are trying to organize the union, so through harassment and intimidation, that often happens. But if workers are actually successful in getting the union, it's very, very difficult, then the negotiation for the first contract is a second time because they can block that. Whereas we think that if workers have decided they want a union, then they should be able to reach a first contract. We also want to see protections for the right to strike. So a ban on replacement workers and reinstatement after 6 months, once you're out on strike for 6 months. Because right now, in the law, if you're out on strike longer than 6 months, you can not be reinstated. Your employer it's totally at their discretion. Jeez, yeah, sheesh. Bad news. So I'm going to pass it back to Mary now.
All right. So those are a lot of great reasons to be fighting. And we believe that we've got a lot of reasons to be hopeful that we can push this agenda forward. We quite purposefully early on decided that we were going to push for a very broad agenda. And after Wynne announced the labor law review in 2014, we moved quickly to have those conversations to develop the grounded analysis and demands. And we got our campaign out before the CWR consultations got off the ground. We have no illusions about consultations. We see how they can distract us from mobilizing. They can wither away or turn into smaller and smaller and smaller tables of experts. So we knew we needed to build a broad agenda that connects with workers' experiences and aspirations, and that could be grounded in that. We wanted to change the public conversation to one that addresses the labor market practices that are creating low-wage precarious work and that makes it hard to form a union. And so when you look at the Special Advisor's interim report released last summer, I think it was over 300 pages, including over 225 options for change. With the exception of, the employer, through all the pages is the employer's plea of no change. But besides that, the business voice was largely absent in the report. Instead, the report outlines how precarious work puts workers in vulnerable positions. It talks about Fisher to business and practices and how employers are shifting liability for employment down the contracting chain. It includes many of the demands of people in the room. The report lays out bold steps to stop big employers from hiding behind temp agencies, subcontractors, and franchisers when it comes to bargaining or complying with the Employment Standards Act. It has other steps to get at the roots of precarious work, such as expanding who's covered under the ESA to make it hard for employers to misclassify us as independent contractors. It provides concrete steps to review and remove exemptions to the Employment Standards Act and the Labor Relations Act. It recognizes the important role of equal pay and treatment for part-time, temp agency, term, and full-time workers, to take away the incentive of precarious work and to treat workers fairly. There are many options to rein in temp agencies, permit temping, and differential treatment. Despite migrant workers being outside the official scope of the review, the advisors heard what migrant workers had to say and raised some steps to protect migrant workers who try to enforce their rights and to form a union. So these are some of the kind of more substantive and comprehensive pieces under the Employment Standards Act, and Shannon's going to talk about some of the labor relations.
They work for me now, I don't need to try to figure it out. As Mary said, there were lots of reasons to be hopeful when reading the interim report. And the special advisors on the LRA side did recognize the importance of upholding the right of association, so the right to join a union, to engage in meaningful collective bargaining, and the right to strike. And there is a general recognition in the document about the value of unions and the benefit that they have for working people. And this sounds like it should be obvious, but in today's political climate, after 30 solid years of serious attack on workers and their unions here in North America and around the world, we can't take this for granted at all. The good news for us on the LRA side is that all of the things like on the ESA side, all of the things we're looking for are actually included as one of the options.